Hello, everyone. I'd like to welcome y'all here for the Ag hearing. I appreciate y'all taking time out so close to Christmas to come listen to this. It's pretty much an emergency for Mississippi as far as I'm concerned, being a farmer and rancher. Before we get started, though, I'd like for everybody to, in silence for Kentucky. I tell you, every time I see the news, it makes me cry watching what's happened in Kentucky and Arkansas and other parts of Mississippi, but it really hit hard in Kentucky. But if y'all will, let's just have a little silence for Kentucky for about 10 seconds at least. Thank you. This morning, I'm glad to have my committee, and we're welcoming a new senator to our committee, Senator Hickman. Thank you for being here for us and the rest of the senators. Today, starting off the bat, we're going to have Commissioner Andy Gibson talk to us about our problems with our elevators. I think you need to sit over there at the podium and talk for us. Let's stand up at the podium, please, sir.
There it's on. Okay, great. Well, thank you, Mr. Chairman, for having this meeting today. Thank you to all of the senators for being here. I already congratulated Chairman McCon. Thank you. Congratulations to you on Chairman of Forestry. I saw that yesterday, and the new member here. Good to have you here as well. I'm Andy Gibson. I'm the Commissioner of Agriculture and Commerce, and I came today to share with you some of the information about, as I was asked to, an overview of our grain licensing process, state licensing process for grain elevators. And when we talk about grain elevators, it's easy to get some of these terms confused. There are warehouses, there are also dealers, and then there are those elevators that are both warehouses and dealers combined. And so I put on your desk there, I've given us a handout there that kind of outlined the difference between those entities. And then to make it a little more complicated, we have federal USDA licensed warehouses, not dealers, but warehouses that are involved. So what I have put out on your desk in a Simpson County common sense kind of way, hopefully, is to outline for you the difference between the three and the different laws governing each one and the process that applies to each one. Before I do that, I want to mention, since we're talking about grain here today, that soybeans, this year's harvest is about 2.19 million acres harvested, and that equates to about 120.45 million bushels in 2021. That's an increase from last year, driven, this increase that was last year and this year, driven by the increase in price and the interest among farmers in this increased price that we see after several years of low and depressed prices. Corn, 700,000 acres harvested in 21, 129.5 million bushels. And there again, another significant increase, again driven by price. And prices on everything are going up. And wheat, I'll just mention wheat, 65,000 acres this year, 3.77 million bushels. Where's all that grain going? Well, obviously, it's going all over the world, Mississippi being a leader in agriculture as it is. But in your handout, I want to refer you to, if you don't mind, the last page of it, which will just show you in very simple format. And by the way, this was just prepared for our grain task force that we've been meeting. The chairman's been on some of the calls. I know maybe some of the others have as well. But where is all that grain going? Our farmers are doing a great job raising it, growing it, and then it's being delivered. As you can see, about 11%, 10.8% of the state of Mississippi production of grain is delivered to state licensed grain warehouses. Another 29% or so if you combine the state warehouses and grain dealers, for a total of 39% goes to, or almost 40% goes to the warehouses and dealers that are state licensed. But the majority, over 60%, goes to USDA federally licensed grain warehouses. And I'll come back to that in just a moment. We are meeting today, as you mentioned, because of the emergency of the express grain crisis. Express grain terminals is a combination warehouse and grain dealer. It started out as a dealer, and I think, by the way, Gene Robertson's our grain division director here, and Gene, wave at him so they see who you are. Gene Robertson's been grain division director since about 2003. So he was there when Express Grains was formed as originally a grain dealer. And then later on it decided to become a federal warehouse, and it became a federal warehouse for about 3 years. And then recently, in the last 2 or 3 years, they came back as a state licensed warehouse and dealer. So they do both. When Express Grain was formed, the same law applied then as applies now. That is, we have bond requirements that apply, and I've put those on the handout here. Mississippi Grain Warehouse has, we can require as the licensing agency, the Department of Agriculture and Commerce can, up to $1 million bond. That is the maximum statutory bond that is payable for the benefit of the farmers in the event of what has happened, which is a default, a collapse, a bankruptcy in this case. And then as a dealer, the law requires, and I put the code section there, another $100,000 bond for those operating as a dealer. Now, interestingly, dealers who are licensed as a federal warehouse, and what is a dealer, by the way? A dealer is anybody who's buying grain from a farmer for reselling or for processing. That's what our law defines in the state code. For those grain dealers who are purchasing grain, they are not required to have a separate license if they're also a warehouse. They're not required to have a separate license if they're licensed as a warehouse. The USDA warehouses do not have to get a dealer license, but that does not exempt them from our dealer laws. The state grain warehouses do not have to get a separate license, but they do have to get a separate bond, an additional bond. So we have today, in the case of Express Grains, we estimate, based on the bankruptcy attorney that I have for the Department of Agriculture, we are in the bankruptcy case, fighting alongside the farmers, fighting alongside the production lenders, and there is a narrow path to victory there. It's narrow and very precarious, but we are fighting for them in that front. But based on the information that's been filed in the bankruptcy, it's about at least 30 million, maybe as much as $40 million of grain that our farmers have not been paid for. So as you can see, the bond, which is a normal size bond, and Harrison Pittman, who's from the Ag Law Center, can talk about what other states do, but it's my first reaction, and yours may be too, well, we ought to increase the bond. But it's prohibitively expensive to do that because it is so expensive, it would drive a lot of our smaller elevators perhaps out of business. So what has been done in other states is the formation of a grain indemnity fund. And when this all happened in September, as you probably have read in the news, Express Grain was served with a complaint for receivership filed by their lender, their bank, UMB Bank out of Kansas City, Missouri. UMB sued them for receivership, saying that they discovered a fraud on September 23rd of this year. When they did that, it required them, forced them into this Chapter 11 reorganization bankruptcy, and that is where we are today. So we're sitting here holding a maximum on behalf of the farmers of the state of $1.1 million, a $1.1 million bond. By the way, USDA, their bond maximum is $500,000 per state, so they don't even have half of the bond that the state of Mississippi requires. All this has given rise to the need, I think, and I appreciate what y'all are doing in looking at our laws. Our state grain warehouse laws and the dealer laws have been on the books since the 1970s, and they have been antiquated for quite some time and have needed updating. I'll talk about some of those updates in a moment. But on the second part of your handout, after this chart, I've printed for you, just for your information, this is an example of a grain warehouse profile off of the modern-day eGrain website, egrain.com. eGrain is an industry standard that shows for warehouses how much grain is actually held in the warehouse and who it belongs to. Because in a warehouse contract, the farmer never loses title to the grain. The farmer delivers the grain. It is the farmer's grain. It remains that farmer's grain until it is sold. So in a pure warehouse context, these are the terms and conditions that apply. You can read those on the eGrain. This is with respect to Express. The warehouseman issues a warehouse receipt to those who bring the grain. And at any point in time, that farmer can back the truck up and get his grain and go back home under a warehouse contract, even in the event of a bankruptcy as we have today. That is not what is happening in Express Grain. The next page shows you what's happening in Express Grain today. Because these are contracts, not warehouse storage contracts, but dealer contracts. As I mentioned, state law defines a dealer as one who is purchasing grain from a farmer for resale or for processing. And this is the standard contract for Express Grains. It is also the standard contract for every other dealer contract for all practical purposes that I know about in Mississippi, because this is the contract drafted by the National Grain and Feed Association. And as you can read it, when that farmer under this contract delivers the grain, he's not expecting to get paid that day, although this Express situation, a lot of people have said they're not going to deliver again without getting their check on that day right there. They deliver it, and in that very moment under this contract, that grain is no longer that farmer's. It becomes the property of Express Grain Terminals. And that,
Excuse me, Commissioner, because they're a warehouse, because they're not a warehouse, correct?
well, they are a warehouse. They're both, but they have contracts for storage, but they also, the farmers at issue in this bankruptcy case, all of them have a contract like this, which says the moment they delivered that grain became the property of Express Grains, and it goes on to say that they can dishonor that they don't have to, if they go insolvent, it all becomes subject to the bankruptcy. So, and it's also arbitration clause. It's almost like a very one-sided agreement favoring the buyer. And let me add this. Gene Robertson, over the years, has been in charge of overseeing the soybean promotion and other promotion fund collections that have been coming in. And we've had instances where there were warehouses that we thought were just warehouses that in fact were buying grain from farmers and were not complying with any of the dealer aspects of the law. So Gene has uncovered some of that over the years. We're looking at it again in the current situation. But I want to make that distinction because the problem is the moment that grain is delivered under that contract, it becomes the property of Express. And then when they file bankruptcy, all of that is tied up in this bankruptcy and the farmers can't get to it. So that's where we are. Now, if I could just go over very quickly, and I'm going to wrap up quickly here. USDA grain warehouses on the left-hand column of my chart. Mississippi licensed warehouses there. Grain dealers here. Let's run down. Authority. Okay, the USDA grain warehouse is not mandatory. Nobody has to comply with it. It's strictly voluntary. And that is why all of the requirements for USDA grain warehouses come to play under what's called a license agreement for grain and rice warehouse operations. It is strictly voluntary. There's no mandatory anything of the USDA warehouse process. Mississippi warehouse, you must have a license to operate as a warehouse under that code section 7544.1. And then for a dealer, the moment anybody, including a warehouse, starts buying grain from farmers for resale or for processing, they are a grain dealer and they must comply with this dealer law. Although if they already have a license as a warehouse, they don't have to get a separate license. That quirky provision in our law is, I'm going to give you that code section here, it exempts the warehouses from dealer licensing under Mississippi Code section Mississippi Code Section 7545304. No person shall operate as a grain dealer without first having obtained a license pursuant to this article. And in 1981, the legislature came back and said, however, grain dealers licensed under the provisions of the United States Warehouse Act or the Mississippi Grain Warehouse Law shall not be required to have a license issued pursuant to this article. What the Department of Agriculture has done with respect to state licensed warehouses, we've said, yeah, you don't have to have a license, but you do have to have that extra bond. And they've complied with it as far as we know. So that's how we have the 1.1 million instead of just the $1 million bond. Going down the line here, I talked about the bond amount. USDA is $500,000, Mississippi is up to $1 million. And we have a lot of smaller elevators, some that are operating as warehouses, some that are operating as pure dealers, some that are operating as a combination of both, and we have lower bonds on some of them. In 2009, Winona Grain failed. We had just over $1 million of farmers' claims in that case. That was before my time, but Gene Robertson can give you the details of it, because in that case, we had sufficient bond to make everybody whole. That we don't have that here today. So we have that maximum bond. USDA also has a minimum $200,000 net worth requirement. Mississippi's, at the bottom of my chart, is only $20,000 for warehouse, $20,000. 200,000 minimum net worth for USDA, 20,000 for state warehouse. But as I mentioned, the increased bond, presumably the intent of the legislature was to make up for that. Financial statements, all three of them require annual financial statements. And in the case of Express Grain, we have received audited financial statements on Express Grain each of the last 3 years since they've been a state licensed warehouse and dealer. And the most recent one was filed with our office in April of this year, April 2021. Totally clean, unqualified audit. The issues, I can talk about the issues, what we think happened with them and their biodiesel operations, if y'all have questions about that, but I'll move on to say, so we have that financial statement. We do that annual examination, and USDA does an annual examination as well, once a year. And then inspection, all three of these situations, at any time, we can conduct an inspection of any questions that are raised. Warehouse receipt, the form of the warehouse receipts for warehouses, you see approved by USDA or us as the case may be. For warehouses, because it's still the farmer's grain, there are insurance requirements both for USDA and warehouse operations, but that's not applicable for dealers, pure dealers. Inspectors, USDA and our current law requires the warehouse to employ an inspector who is responsible for weights and grades on all those warehouse receipts. This is where our law is really weak, and I want to emphasize this. And failure to pay, there's no timeline for a failure to pay under USDA. At any time, if there's a failure to pay as determined by that farmer, it can provide notice, and the USDA can go in and basically recover it, operate it, whatever, take it over. For a Mississippi state licensed warehouse, failure to pay within 10 days of the demand of the holder of the warehouse receipt, they can then go against the surety, the bond. But here's the weakness. For a Mississippi grain dealer, and that's the issue we have with Express, who's bought grain from the farmers directly, that producer must, under our law, antiquated law, notify MDAC in writing by certified mail 160 days or 10 days after that from the date of sale or delivery, or if sold under a deferred or delayed or futures contract pricing agreement, 270 days of the date of delivery. And they've got to do that all by certified mail, and then we can conduct an investigation. I asked Gene to go back and look in our records. To our knowledge, that has never, ever been filed by anybody with the Department of Agriculture. I mean, asking a farmer in this day and time to do a certified mail, 160 days, this narrow window, it's a long time after they hadn't been paid, then that allows us to move in and that needs to change. And that goes to the issue of the hotline I'll talk about in just a moment, and others will talk about as well. Penalties, you see the penalties. Federal, criminal, civil fraud, state, willful violation of provision of the law is a felony for a warehouse, but for a dealer operating without a license is $100 to $500 for the first violation, $200 to $1,000 for each subsequent, 6 months, so it's not a felony, in prison, and then we can apply for a temporary injunction. And then I mentioned the net worth. There's a $200,000 net worth requirement by the feds, $20,000 by the state law, and there is no minimum net worth for a grain dealer. However, I'll point out, a lot of our grain warehouses that we license are also dealers. They're operating as dealers. So Gene has gotten on the phone in the past and called some of the warehouses and said, are y'all buying grain from farmers? Are you buying grain from farmers? To find out if they're acting as a dealer or not. And we do have one federal grain warehouse that is registered as a dealer that has got it covered both ways. Now, I want to wrap up by saying when this happened, I found out about the bankruptcy the same time the farmers found out about it, September the 29th or 30th. An email came out from the owner at that time of Express Grain and saying his bank was shutting him down and so forth and so on. I got him on the phone, and his story then, and as recently as last Friday, is that he's working on a deal to sell this thing, and he's got investors lined up, and everybody's going to get paid. Well, that remains to be seen. That'll all be decided in this bankruptcy proceeding. But I don't think any of us think we should wait on that to take action, and I know y'all don't think that. So we formed, with your involvement, a task force back in October. It has had 3 meetings to review these issues and make recommendations, or at least build consensus about what to do. And I know Farm Bureau has also weighed in on this. So we had a task force meeting yesterday, and the 3 policy recommendations, I'm going to touch on them very briefly and I'll take questions, but just hitting the high points. I don't want to take up everybody's time. Most states have some form of a farmer's indemnity fund, where farmers pay in a percentage per bushel amount to cover a loss in the event of a grain storage, a grain elevator default, grain elevator collapse. Mississippi does not have one. I think Harrison can tell you how many people have one, but the task force that we assembled, which is represented by farmers from Farm Bureau and Delta Council, in our meeting yesterday, the consensus was supporting a voluntary, not a mandatory, but a voluntary indemnity fund for grain farmers to 0.2% of market price per bushel to fund it. And I think the general consensus was maybe a $20 million fund administered by farmers outside of the reach of state bureaucracy and payable to farmers in the event of a default, and a revolving fund that could be repaid over time. If there were not a claim in so many years, those who participated on the front end could get their funds back. I think those were the high points. The chairman of that task force is Ted Kendall here, who will be talking in just a moment, and he'll give you some more details. And I know that Frank Howell and Patrick Johnson have some more details as well. Secondly, when this happened in Arkansas about 5 or 6 years ago, 7 or 8 years ago, Turner Grain failed, and the Arkansas legislature looked at this, and their determination was simply to establish a slow pay hotline instead of this long certified mail process or some other burdensome process. Just if you hadn't been paid, here's a hotline to call. It can be done anonymously. Presumably anybody in the community could call to report any suspicious activity, a hotline, a slow pay hotline, and certainly that's a good common sense approach. And certainly we support that. The task force developed a consensus to support that concept of slow or non-payment. And then thirdly, this actually came out of the Farm Bureau policy to support increased funding for our agency to fully staff the grain dealers and warehouse division. to investigate and to follow up in real time on the slow pay events or no pay events or whatever the case may be. We appreciate the legislature's support over the years. And pre-recession, I was here during the recession. I remember when the legislature didn't have any money. And I remember budgets being cut, and Lydia, you do too. Every time we turned around, the governor was cutting budgets because the money wasn't there. And the result of that, at the Department of Agriculture, we're a fairly small agency, but we do important work. We have a total of about 178 employees, and most of them work out of their vehicle on the road. But we were operating at about 2/3 of our regular budget when I took the reins in 2018. What that meant was there were less people doing more work. Gene Robertson, who's over our grain division, also does the catfish aquaculture program. He does weights and measures. He does a little bit of everything. And at one time in the past, we had 5 inspectors that were employed at the Department of Agriculture who were on the road, like our petroleum inspectors and like our consumer protection inspectors. We don't have those pens anymore. Our pens were reduced again this past year, and we're happy with the level of funding that we have. But if we're going to have the ability to respond in real time to these types of events when they happen, when God forbid a hotline comes in and somebody says, hey, you need to go check this out, we need somebody on the ground. So that's one other aspect of it. And, you know, we have about 30 licensed grain dealers in the state. We have about 14, am I right, grain warehouses. Some of those warehouses also operate as dealers. So I'm estimating we could probably get by with, if we had 3 people, if we had 3 pens, that we could pay somebody a living wage to get on the road and visit each of these every so often, like we do our just unannounced inspections. That would go a long way, I think, not only in terms of detection, but more importantly in deterrence and keeping this from happening again. I want to thank you for your time today. Thank you for allowing me to be here. I'll take any questions that you may have at this time.
Thank you, Mr. Chairman. Committee members, anybody have any questions? Senator Seymour?
Thank you, Commissioner and Mr. Chairman. Andy, if you have more investigative ability, when a grain dealer's cooking his books, is there any way to truly catch him before the act has done its damage?
That's a great question. Detecting fraud, if somebody is cooking the books, if there is actual fraud going on, and it hasn't been proven yet, but there's a lot of evidence that something was fishy going on here. I can talk about it if you'd like to. You know, what we have is audited financial statements that an independent auditor has reviewed, gone through and said everything checked out fine. If they didn't catch it, if their bank didn't catch it for as long as they say they didn't catch it until this September, and they filed the same information with our department as they filed with their bank and with their auditors, and I don't know, I can't guarantee you that we could catch a true fraud cover-up before it's too late. But I'll tell you this, we'll do everything we can. I mean, if we don't know about it, we can't investigate it. And if nobody calls and says they hadn't been paid, we can't check into it. Now, we did have one farmer call in Express last December on a slow pay. And Gene actually talked to that farmer, and he talked to the owner of Express, and the owner of Express said, call my banker. And he called the banker, and the banker said, everything's fine. It's just paperwork, and the farmer got paid, no harm, no foul. So that type of thing, if it's in fact routine, we can help respond to. But if it's a true fraud, I mean, look at WorldCom. I don't know who could have detected that. Nobody, the SEC couldn't detect it.
Andy, one last question. When it comes to the bank that basically foreclosed on this company, does the state of Mississippi do any other business with this bank that you know about?
Not that I know of. It's an out-of-state bank. It's a Kansas City bank. They specialize in grain. I don't know. Maybe they do, but they specialize in grain lending operations. If the state of Mississippi deals with them at all, I don't know about it.
Thank you.
This is a good question. Yes.
Mr. Commissioner, you've asked for currently restoration of pins and additional funding. Was this not on your radar last year when we did some additional funding for some projects, or was this just knee-jerk reaction at this point, thinking that we could fix it with 3 new people?
Well, we've actually asked for these pins for a long time. We've in the budget process, and we've asked not to cut these pins. And what we have a lot of pins that don't pay a living wage, like $18,000 or something like that. And we've asked for we've actually asked for this before. This is not the first time. What I just mentioned to you was Farm Bureau policy supporting that, which was just passed at this past Monday's Farm Bureau annual meeting. And then our task force also supports it as well. So that's the reason I'm bringing it up today.
Well, I understand Mr. Kendall's going to be over here speaking on Farm Bureau and bringing those resolutions to us. Additionally, was there any other investigation or any follow-up after the slow pay incident? I mean, it should have put us on the radar to be concerned about these people. Was there any additional follow-up, new records, or requests done by the agency?
Well, yes, and as part of our annual examination of them in April, they submitted their financial statements again for this past fiscal year, and they were reviewed, they were documented. We have a process that we go through with a accounting employee that we have in the office, going through all those, checking it out, making sure it's an unqualified opinion, and everything checked out. So, yes, we did that investigation in April, and did not hear of any issues. Nobody else called. Nobody else raised any issues with them until after the lawsuit was filed by UMB Bank in September, I think September 28th of this year.
And that lawsuit actually was in the middle of harvest. So, at that point, we have people that more than likely were used to waiting a few weeks to get their checks as the warehousing there. So, Mr. Chairman.
Mr. Commissioner, I've been told, do you receive their financial audit, or does the bank receive it in St. Louis?
I received it.
And it was good for the last 3 or 4 years?
I have in my office 3 years of audited financial statements, unqualified audits, meaning a reputable local CPA firm looked at them and signed off on them. And that same information, I presume, I don't know what was filed with the bank, but I'm assuming they filed the same information with their bank. But they did file it with us. And if they lied on them, they lied to the state of Mississippi.
But the accounting firm, they said they looked good.
More than look good, they are unqualified. They put their name on it as an unqualified, no material misstatements, omissions, significant deficiencies, internal controls, anything like that. It's what's called they gave an unqualified opinion on each of the last 3 years as recently as this April 2021.
Well, I was told from 18 on that they didn't look good. Maybe that's hearsay.
Yeah, I'll be glad to give them to you.
So you don't think that we need to go with USDA? We need to stay with the state on giving the license to these elevators?
For warehouse purposes?
Yes.
Or for dealer purposes?
For all purposes.
Well, USDA doesn't license dealers, so you can't do that.
Well, we could change the law and do that.
The federal law does not authorize federally licensed grain dealers, just warehouses. That's the way that law is structured. So we'd still have a dealer law. I think I've talked to the folks at USDA. Most of them had not come back to work quite yet. The USDA announced this past week that they're working on 8 out of every pay cycle, 8 days work from home. And I honestly believe, given the people and the resources, our folks could do a better job than USDA. I'll give you an example. USDA contracts with us to do their own meat inspection program. So when they tried to put a mandate on us the other day, And I said we were not going to do it as a federal contractor. They backed off because they didn't have the people to do it. I can talk more about that. And they didn't make us do vaccine requirements either because they know they can't do their job. So I'm not putting USDA down. I just have enough dealings with them to know it's not, I don't even think they get around to them every year, honestly.
Well, I've got a good friend of mine that runs an elevator where I live, and matter of fact, he's holding my crop for me right now. It's already been sold. He's holding the money, the bread, yeah. And I'm letting him hold it until after the first of the year. And if he reneges on me, I'm going to kill him. But
oh,
but
is
anyway,
is it storage, or is it warehouse, or a dealer, a contract?
Well, I guess you would say he's a warehouse because he, you're telling us the warehouse is where you can take it there and they own it.
That's right. No, warehouse is where you take it there. It's still your grain.
It's still, yeah, okay, well, that's them. They're the warehouse.
So
and then they charge you a nickel a bushel
right
after the first month. They'll let you have the first month free. But you know, he runs a good business.
Sure.
Of course, all the farmers there complain because his basis is real high. Meaning if it's, you know, $13 in Chicago, he's got a 50-cent basis, which he's only paying $12.50. So a lot of the farmers complain because his basis was too high. Well, the elevators have to make money. But, you know, that's one of the stink on this is because Express Grain was paying above Chicago in some place and some of their contracts.
Yeah.
And then the other stink is this the bankruptcy judge is wanting the farmers to honor those contracts that they haven't fulfilled yet, and he or she, the judge, is letting Express Grain throw away the contracts that won't make them money. But they want the farmers to honor the contract. So they're wanting the farmers to honor the contracts that they're not making money on, that they're making money on, but they're throwing away their contracts where the farmer would have the advantage and make money on. Of course, none of the farmers want to take any more grain there, period.
Right. And that's in that fine print of that dealer contract I showed you, that's where they say it is very one-sided to give them the right to do that sort of thing, especially in the case of bankruptcy. It's buried down in that contract, a dealer contract, not a warehouse contract. And in his case, what he has said was he had this other biodiesel project going. So he was buying this grain, and then it wasn't even going in storage. It was getting on a train car going out to the biodiesel, which it was his at that point legally. And then they were losing all that money on that. But what he was telling farmers back then was, I can pay you more because my oil is more valuable, et cetera, et cetera, et cetera.
So when the Department of Ag, when y'all go do a grain audit, y'all do that, right, to give them the license?
Yes, we have. Yes, we do that every year. To get them, every year they renew a license. We look at everything, their books, records, everything.
Do y'all measure the grain to see how much grain's in the bins?
For a warehouse or a dealer? Because in a dealer, that grain hasn't got to be in the bins.
For a warehouse?
For a warehouse, all that information is on this eGrain website where the warehouse receipts, what we do, this is in real time. The warehouse receipts for example, Express Grain Warehouse. You go to egrain.com, it'll show you every person who holds a warehouse receipt for grain in that storage. And then we can compare it to the total bushels in that particular warehouse. And yeah, if we needed to go out and measure it, we could, but we'd have to be told or have reason to believe it wasn't there if it were missing in a pure warehouse. But that's not what we have here. What we have here is a dealer who has a warehouse operation, and all of his contracts are buying from the farmers and basically going out to fund this, to supply this biodiesel factory. And so it was never, in a lot of cases, wasn't even in the bins.
But I would still want to measure the grain bins, would you not, to check it, to make sure it matches with what they're saying they've got on paper?
We can certainly do that. We can go out and measure.
We haven't been doing that, though, have we?
We can do that at what point in time is the right time to do that? I guess we could set a particular point in time at the height of the season. But yeah, we would be happy to do that for a pure warehouse. And I think we, as I mentioned, we have counted up 14 grain warehouses that are licensed, Mississippi state licensed.
Well, I know my good friend back home, they have USDA inspected, and he tells me every time they come in, I've called him before and they were there, and he said, I can't talk right now, my stomach's in knots. Yeah. He said they're checking they're checking canceled checks, they're checking how much grain we've got, and you know, when a farmer gets through planting, they have to go to the USDA office and report everything they've planted, what they planted, when they planted it, and then they have to, of course, give that to their lender, the bank or whoever, and then they have to give it to their crop insurance consultant, person, whoever they have their crop insurance with. But anyway, we sure appreciate you being here today. Any more questions from any of the committee members?
Glad to do it, and if that warehouse, that friend of yours is holding your grain, it's still yours. You can get it whenever you want it. It's there.
No, it's his now.
Oh, he sold it?
I sold it to him.
Okay, so he's a dealer.
After the first.
So he's a dealer then. He's got a dealer contract as well. Yeah.
Oh, I'm sorry, Senator Hill.
Thank you, Mr. Chairman. Mr. Commissioner, I appreciate you giving the difference between a warehouser and a distributor. And I think that's where the disconnect lies in this particular instance, where this guy was just basically buying the grain for himself and using it in his biodiesel business. So a warehouse, somebody that was actually warehousing grain, rather than being a dealer, that's just holding grain for somebody.
That's holding grain for the farmer. It's still the farmer's, and they have to maintain insurance on that grain in case it burns down or a tornado hits it like happened in Kentucky. Right.
So that's what the warehouser just has to maintain insurance for the farmer, and that's why the farmer pays him to hold that there in security until it's ready to be sold, correct?
Correct.
Okay. I appreciate the clarification. You know, I know we've never had a situation that I know of in 10 years where, you know, we were required to go out and measure somebody's grain that was being held in a warehouse. I mean, it's like cattle theft or anything else. Until it gets reported to us, we don't know anything is going on. And basically, this bank that you spoke with when you were doing this investigation, either they were just stonewalling or they were, no, we don't know what they were doing, but they told the Department of Agriculture that everything was kosher. And so basically, anytime anybody's trying to go do business with somebody, you're going to get a credit bureau check or whatever, and those financial institutions are basically the be-all, end-all in telling, you know, whether or not somebody's solvent, correct?
Well, yeah, I think the financial institution's going to know really before anybody.
Or should
if there's
know,
a problem.
and should have reported it to you if there was something going on at the time that you investigated.
If they were allowed to do that under the banking laws, they might say they weren't allowed to, but somebody could, if we could do this hotline, which we plan to do, somebody in the community could call and make us aware of it. We got to know something bad's happening, and we can send somebody up there.
I appreciate that, because I had to get educated on this. I didn't know the difference. I mean, because I'm not in the grain business, but I think that it's been helpful to learn the difference and what the USDA typically does and what they typically do not do in their scope of work. Yep. So appreciate it. Thank you.
Thank you.
Senator Chasnoff.
hate high tech. Thank you, Mr. Chairman. Thank you, Mr. Commissioner. In listening to your presentation, of course, you brought up some things that I've been painfully aware of because of prior experiences with other elevator companies that have failed. It seems to me the one missing piece of this puzzle that you have presented to us and done such a great job of explaining it to us, what about this accounting firm? Are they culpable in any of this? Because they've basically been telling folks, hey, everything's fine. This is just all hunky-dory. Y'all are doing business with a solvent company. Is there any way that the accounting firm who has given an unqualified report of this company, is there any way they or other accounting companies could be held accountable for basically misleading the farmers? I'm on the side of the farmers. I want you to understand that, because plenty of these folks that are affected are my constituents. Yeah. And I'm heartbroken for some of them. I mean, I'm sad for the people that have gone belly up, but farmers are in the business of growing the crops. They're in the business of producing, and it really concerns me that maybe they've been told, hey, everything's fine, just keep on rolling along, everything's going to be fine. And I just want your thoughts on that, if you don't mind sharing it with me.
Well, yeah, there have been discussions about that since all of this litigation was filed, even the UMB lawsuit against the Express Grains. It has been discussed, why didn't the auditors catch this? Even our law says that the commissioner may require an unqualified audit opinion. And that's what we have in this case. So it's kind of the gold standard of what you would look for in an examination on an annual basis. We have that. Where was the disconnect? I do not know. There are a lot of theories about why this grain was losing money over in this biodiesel project, and it wasn't operating efficiently as they claimed it was, and so forth. So I think there's plenty of culpability to go around, and I think you raised a good question, and it's probably going to get answered before it's over with.
Mr. Commissioner, can we get a copy of the audits?
Yeah. I'll give you all the 3 years that we have, 3 fiscal years.
Thank you. And we're not trying to point any blame here. We're just trying to fix this where it won't happen again.
Yeah. I agree. I think we all agree on that. And so our task force is going to talk to you in a little bit, or will be mentioned. We have some recommendations for y'all to consider, and it's certainly all of their recommendations are the recommendations I support and will support during the regular legislative session. And they're all common sense proposals, and I think they will keep this from happening again.
Thank you so much, Mr. Commissioner.
Thank you for having me. Thank you, and Merry Christmas to y'all. By the way, I put a market bulletin not to have y'all buy something, but to show you the pecan theft law that you passed last year, the Senate passed, that didn't make it out of the House. I wrote a special article about it, being Christmas time and pecan pies and all. And they made a joke out of it in the press last year, and it's not a laughing matter for our pecan farmers. So thank y'all for passing that. I hope y'all do it again, and hopefully the House will get on with it. Thank y'all.
Thank you, sir. Next up, we have Harrison Pittman, Director of the National Agricultural Law Center, speaking. So glad you took time out to come speak to us, Mr. Pittman.
How are y'all doing?
Doing good, thank you.
I think there's a PowerPoint. That's getting all booted up. So I'm Harrison Pittman. I serve as director of the National Agricultural Law Center. We're headquartered in Fayetteville, Arkansas. We serve as the nation's leading source for agricultural and food law research and information. So basically what I do and the attorneys and our large staff that we have, all we do is agricultural law and food law every day. I've been at it about 20 years. Our mission at the center is to serve as an objective resource. We're a nonpartisan resource. We work with state agriculture departments, Commissioner Gibson, and regional groups like SASDA, the Southern Association of State Departments of Agriculture, the national groups, NASDA, state farm bureaus, American Farm Bureau Federation, producers of all kinds all over the country. You know, from the West Coast to the East Coast, every type of commodity, from aquaculture to forestry to row crops, specialty crops, organics, and so forth. And laws at the state level, the federal level. And so that's our basic function. Out of everything I just said, which you can take from that, I think that would be the most helpful is that I'm not an advocate. I'm not here to help persuade you one way or the other, but to be an objective resource for information. You can ask me anything you want. I'll do the best I can to answer it, and if I don't know, I'll certainly follow up with you. How are we on PowerPoint? Okay, it's all good. This issue of failure of a grain, I'll say grain elevator, okay? And when needed, I'll do my best to distinguish between a warehouse and a dealer, but I use the term elevator to kind of capture both. One thing it might help get your mind around that, the grain industry has really evolved, and that's a really important context here. So a lot of these laws, like Mississippi's and so many other states, these laws were written at a time when the business looked very, very different, okay? So, for example, it's common to see in some of these state statutes that a grain warehouse will need to have or demonstrate they have $20,000 cash on hand to help demonstrate their solvency and that they can cover in the event that there's a loss. Well, that's nothing today. These elevators, they do dozens of millions of dollars oftentimes. Do we have a clicker or anything? Or how do I? Okay. Yeah, we'll make it work. And there used to be far more common for there to be a warehouse, and that's all that they did. They simply took grain and they stored it. If you kind of want to see just a quick image of how the industry's changed in that regard, you drive through western Mississippi, you drive through eastern Arkansas, and we're heavy row crop country, you'll see a lot more operations, farming operations that have a lot of storage that wasn't there 15 years ago. So farmers store a lot more of that themselves. And so the industry's changed a lot, and it's far more common today for an entity to be both. They will, similar to Express Grain, they'll have a warehouse component, and they'll be dealers. And the distinction is not so much about storage, that's important. The distinction is title, who owns it. A dealer buys it. A dealer's taking title, they're taking ownership. And it's the nature of these contractual arrangements, it's far more common these days to have deferred pricing and deferred payment. In other words, you deliver, title changes, but the price is often discovered later. But they can be determined on the front end too, but payment is delayed. Another small wrinkle, as I was listening, I was kind of thinking through where the questions were coming from. Another small wrinkle that often happens is a producer will purposely leave the check with the elevator simply because of tax reasons. Like it's advantageous to wait until typically after the first of the year. And so sometimes the producers, they're lawfully entitled to payment, but they actually don't want it. That's not that uncommon to happen. And so that's just one of the wrinkles in this. Next slide, please. So I think I've pretty well covered the background about the Ag Law Center. I do want to reemphasize, we are an objective resource, a nonpartisan resource. We work with lawmakers and policymakers and people in agriculture all over this country. This issue of the grain elevator failure is sad, and you know, my heart goes out to the folks that are impacted. We had a similar situation. It was alluded to a few minutes ago in Arkansas. With Turner Grain, and losses there were approaching in the $50 million range. And that's a very painful loss for a lot of farming operations and the communities and the lenders and everybody that gets soaked into that. But it's also unfortunate that this isn't new. This is very familiar territory for me. Over the years, I'd say it comes in ones and twos or threes every year. From Nebraska to Iowa to other states, there's always somebody that for whatever reason, they run into money trouble as an elevator. And these questions come up, and so this isn't even the third or fourth or fifth time that I've dealt with these issues. So, all right, next slide, please. I was asked, I want to focus mainly on indemnity statutes that exist around the country. But I was also asked to do a kind of a quick comparison with some of the neighboring states, particularly on licensing and bonding. Next slide, please. So Commissioner Gibson covered this pretty well already. I won't reiterate very much about Mississippi. Mississippi has two different statutes that matter here at the state level. There's one statute that deals just with dealers. There's another statute that deals with grain warehouses. The Mississippi Grain Dealers Law of 1978. Most provisions of this have never been amended since 1978, and I talk about how the industry's evolved to kind of keep that context in mind. It requires a surety bond or a certificate of deposit or irrevocable letter of credit. That's not uncommon. That's very similar to other states, in an amount equal to 10% of the aggregate dollar amount paid for grain in the previous fiscal year, not less than $25,000, not more than $100,000. Under the Grain Warehouse Law, it requires state license unless it's licensed under the federal warehouse law, which is the United States Warehouse Act, USWA. And this is also similar to other states, that you furnish a bond or an equivalent financial instrument in an amount of 25 cents for the first 1,000,000 bushels of storage capacity. You go up to 20 cents for the next, and then 15 cents for anything that goes over 2 million. That's similar to other states. And there, as the commissioner mentioned, that's not less than 15,000, but not more than 1,000,000. Next slide, please. Arkansas, the state that I woke up in this morning, for grain dealers. So I want to put this very quickly in context. When I mentioned Turner Grain and the failure, the Turner Grain was a grain dealer that had the same problems as Express Grain's having now. They basically ran out of money. The music stopped. At that time, as astounding as it sounds, Arkansas did not have any law dealing with grain dealers. Completely unregulated, did not require a license, didn't have bonding, didn't have anything. And so what you see in this, I'm just pulling a snippet of it. This was all new to the state. This is the state's first iteration of a grain dealer statute. It does require grain dealers to be licensed. It authorizes the state plant board, which is an entity underneath the Department of Agriculture, to require a surety bond, financial reserve, or other evidence of creditworthiness. And they really kicked that authority over to the Secretary of Agriculture in Arkansas to make these determinations as to what that actually financially equals. For grain warehouses, we have had a law there for quite some time. They do require a license. It has to be under either the state or the federal law, one or the other. And the bonding requirement just is very similar to what I mentioned for Mississippi. It prorates up based on the amount of storage capacity per 1 million. Next slide, please. Tennessee, they have a statute that it's not separate, similar to Mississippi, or like Mississippi is, where you have a grain dealer statute and you have a grain warehouse statute at the state level. Theirs is all under one statute. So it tackles grain dealers and grain warehouses all under one statute. So it requires the dealers and the warehouses to obtain a state license. Their state law states that the federal licensed warehouse are subject to the state law. It requires a surety bond as well as fire and extended coverage insurance policy, which Commissioner Gibson mentioned that in Mississippi, very similar. And that's not uncommon at all to have that level of insurance. The question sometimes comes up about insurance for losses, similar to that's pulled us here today. That's not, to my knowledge, ever been achieved, simply because for the insurance companies, the level of losses compared with the premiums required don't really pencil out. And then the bond amount is established by the Commissioner of Agriculture in Tennessee, no less than $20,000 and no more than $500,000. Next slide, please. Neighbors to the south, Louisiana, similarly have a statute for ag dealers and warehouse. It requires a license for both, a surety bond, and again, you can see this prorated portion up for what the bonding amount would be. And again, $15,000 at the minimum, $500,000 at the top. Next slide, please, and let's see where we are. Okay, so one thing to keep in mind on these bonding levels, particularly in today's economic or market conditions with the grain markets, the grain economy, it's easier to think of a bond as more like, it's like putting ante on the table playing poker. They're not really intended or even capable of covering the kind of losses that can be experienced. They were closer to that, when they were put in place many years ago. And, you know, it's a tragedy, but, you know, typically, when the music stops, that's when everybody really stops to start learning and listening, and that's when these things get revisited. And obviously here we have a music stop situation. But the bonding is important. It does kind of give a sense of financial health, but it's really not as pure of a test as it used to be, and it's really not that effective at covering the types of losses that you have. In a moment, I'm going to turn towards talking to you about the grain indemnity programs and what states have them and what they basically look like. But before I turn to that, you know, there was mention of the hotline, you know, some form of notice being given to appropriate state authorities and how to deal with that. In my view, in my experience, that is one of the most singularly important aspects in all of this, this issue. There has to be a mechanism by which an affected party, it's almost always going to be a producer, knows and then has to use this process to send the warning signals of a slow pay. In my view, and again in my experience, I think that the safest thing from an ag industry perspective, and particularly a producer's perspective, is to assume that slow pay equals no pay. Slow pay equals no pay until you're proven otherwise. And what I would analogize is to, you know, we heard the $40 million mark. That's a tremendous loss. That's a lot of money, particularly in the ag economy. That's a pretty big hit. And there's been others around the country that have been bigger than that. There's been others that have been smaller than that, a lot smaller. And the analogy I would use would be just like you and I, if, you know, let's say that you maybe have a lump in your neck or something that concerns you. You go to the doctor. You go right, it's similar, just follow this analogy with slow pay. You go to get it checked out immediately, and the doctor says, I'm glad you came in because this is a cancerous tumor. We caught it early. We're going to be able to treat this. We're going to be able to mitigate the risk here, and we're going to be able to remove this. There's treatment. Compare that to waiting. You know, you have the lump. You have the slow pay. It drags on. It goes on. It gets worse. It metastasizes. By the time you go to the doctor, they say this is really quite serious. It's really gotten farther along, and it's kind of showing up throughout the body. This is going to be a much more difficult treatment. We're kind of at that stage. When you get to the 30 million, 25 million, 20 million plus, and so in this whole context of thinking about licensing and bonding, and I know that this is a new area for a lot of people, I would encourage you to think about process and how these things happen. And when someone has that slow pay, they need to be able to, and they need to do it, not just have the capacity. They need to take that responsibility, and they need to report that. It needs to be dealt with, and then that process starts triggering. Once that happens, then it begins. The story will tell itself. If it's a one-off, you'll know. But the trick is you catch this when it's at maybe 5 million or 6 million. It never gets, you don't get that far along to where it becomes such a huge loss across the sector. All right, so let's turn over to grain indemnity statutes. So we keep saying it, but what are they? I think everybody probably has a general idea. But these are state law established funds designed to compensate eligible producers for either most or all losses that are incurred as a result of an insolvency or a no pay or slow pay grain dealer or warehouse event. So when we get, I'm fast forwarding or sort of foretelling here, when we get to the part about whether it's voluntary, whether there's an opt-out, whether there's refunds, that's where particularly this issue of eligible. Who's eligible? And usually it's those producers who pay into it. If you have a voluntary aspect to it, and those who don't, they don't get to participate typically in the fund should there be a loss. This is usually in addition to the bonding, and so in some of these state laws, the first money that is paid out, it comes out of the bond, and then it goes over into this indemnity fund. So what states have those. So let's go to the next slide, please. The states in red here are states that have in their state law an indemnity program established. To put this in maybe a little bit broader context, this is, I think, 13 or 14 states. Honestly, I should have counted again. I don't remember. But we're basically 13 or 14 states. There are about 33 or 34 states that have some type of grain warehouse and or grain dealer statute. And so of those 34 or 33 states, 13 or 14 have an indemnity program. As you can see, neighbors to the south, neighbors to the north, and pretty much it's states that run down the Mississippi River. No accident there that historically, but this is the stream of commerce for our country's history of agricultural products moving out through the country and around the world. And so it makes sense that you have a lot of these elevators and warehouses along the river system. And that just happens to be a lot of where these statutes have arisen over the years. Next slide, please. So the next 3 or 4 slides, what I've done, I have pulled out what are really the general areas that are commonly covered in these statutes. This doesn't cover, everything, and not all of these things appear in each one. The first, there's going to be the creation or the establishment of some type of entity that oversees it. So that's going to be, in some states they may create a state corporation, or they may authorize the creation of a corporation. It's typically going to look more like a checkoff board, where you have individuals from the agricultural community who serve on that board. It's voluntary, and they oversee that fund. They're essentially fiduciaries, and they're the ones that make decisions about, or they either make the decisions or they're part of the process in determining whether claims that are submitted are to be approved and paid. So that's a key part of it. They're all going to have assessments. I've mentioned that some of these have refunds of these assessments, and others will have what's called an opt-out, and some, like Kentucky, merge both of those concepts. You'll have some of these laws, less than 4 of them, I think, that have some kind of reentry. So if a producer decides to opt out, or they ask for a refund and they therefore at that time lose the protection of this indemnity fund, with some strings attached, they can come back into the program. But they have to make up typically for what they didn't pay in the past, plus a penalty, some interest that goes along with that. And they're not all approved. They have to apply for that. It has to be approved, and that goes back to that board concept. I think I've covered this second bullet point pretty well. A really critical feature are the minimum, maximum amounts. All of these laws will have a cap. So that cap might be 10 million. That cap might be 8 million. It might be 15 million. Some are 20 million. There's one, I think it goes as high as 25 million. And what that means is the assessment is collected until it hits that cap, and then the assessments will be suspended. They stop. The best comparison would be with the checkoff program, where those never stop. Producer delivers grain or even cattle. If you go to the livestock side and pay $1 per head, those continue no matter what. These will actually stop at some point, and they don't pick back up until the fund for, typically because there's going to be an insolvency and there's claims made against it, and it goes back down to a certain amount. So maybe I'm just picking raw numbers. So let's say it's at 15 million. There's an insolvency, there's claims made, there's claims paid out, and it goes to $12 million. Well, the state statute might say, well, the assessment doesn't pick back up until it goes to $10 million. And so the assessment, even at that point, might not pick back up. These funds will earn interest as they stay there. Some of the states, they actually will expressly authorize these boards to invest these funds for the benefit of the trust, of course, or of the indemnity program. There will have to be a process for claims, a formal process. If you have a loss, this is how you file. You have to file within this time period, so forth and so on. And there'll be a requirement that the dealer or the warehouse has to reimburse the fund for the amount that was paid out. You can see immediately the catch-22 there. If they're truly insolvent, if they're truly broke, they don't really have the money. But that also goes back to that catching it early. And, you know, in some of these circumstances, if you catch it early enough, there can still be enough assets available to recoup what was paid out of that fund. Next slide, please. These next two slides, I think it's just a couple of them. What I've done is I've gone through the states that you saw in red, and I've put what their assessment is. And the 0.2% that was mentioned earlier, and I think will be talked about again with respect to the Mississippi Farm Bureau policy, is in line with what a lot of other states have done. Idaho, it's determined, they allow the Department of Ag to determine it, but it shall not exceed 0.2% of the total gross dollar amount without deductions. Indiana, same amount on all marketed grain that is sold to a first purchaser licensee. Iowa, it shall not exceed 1/4 cent per bushel assessed on all purchased grain. Kentucky, 0.0025% of the gross value of the grain. Louisiana, which kind of gets to the specifics of how this can apply differently in some states, will apply both to grain and cotton. And that's 1/25 of 1% sold to grain dealers and cotton merchants. Michigan, not more than 0.2% of the net proceeds. Next slide, please. Ohio shall in no case exceed 1/2 of 1% bushel. Of course, they leave that over to the Commissioner of Agriculture in Ohio to help determine that. South Carolina, an assessment of 2 cents per bushel must be imposed on all grain, other than grain for which a prior grain dealer has already paid the commission. Tennessee, 1 cent per bushel of soybeans and 1/2 cent per bushel on all other grain. Tennessee has a quirk that appears in a couple other states as well, but they have a referendum process that has to go through in order to set it up in the first place. So producers actually vote to set up the program in the first instance. The state of Washington, again, they kick it over to the regulatory process to be determined by final rule, but cannot exceed 5% of what the amount of the bond would be. So next slide, please. The maximum minimums. Idaho, 10 to 12 million is the maximum, has to be maintained at that level. Indiana, it's collected until it hits 25 million and it restarts when it hits 20 million. Iowa, the assessment is collected until it hits 8 million. It restarts when it goes down to 3 million. Kentucky, it goes until 3 million, but if it falls below 3 million, the assessment kicks back in until it hits 10 million. And then would restart if the fund decreased to 6 million. You can mix and match this stuff any way you want. You can kind of get the concept here, though, as going through this. Louisiana, it's collected until it hits 12 million. It restarts when it hits 10 million. Next slide. Michigan, it goes till 3 million. And then Michigan is unique in that even when it hits that cap, they do a pretty much smaller assessment, and that's to help cover administrative costs going forward. Which is something that has to be considered. A portion of this fund will be used for administration in carrying out the program. Ohio goes until 15 million, restarts when it hits 10 million. There they call it an advisory commission. They have to consent to that. That's that farmer board that I mentioned earlier. South Carolina, it goes till it hits 3 million, restarts when it hits 1.5 million. Tennessee, they've added to theirs after original enactment. It's initially paid until it hits 3 million. They amended in 2011 to pay the assessment until it hits 10 million, and then restart when it hits 8 million. Washington, a statement, the assessment goes till it hits 3 million. All right, next slide, please. This is an important aspect. I've gotten quite a few questions about this. Some of these programs are just straight up mandatory. There is no opt-out. It's mandatory. Others do have this opt-out concept or a refund. Indiana would be an example of a refund/opt-out state. Kentucky is an example of a refund opt-out state. And I actually should have just said, I got that right. I've got one state ahead in my mind. Sorry about that. Kentucky, I'll repeat that for clarity. Kentucky is a state that has an opt-out and a refund provision. Tennessee just has strictly a refund. That was the one I was thinking about, and I got it wrong. They have an opt-out. They don't have a refund. And I'll explain each of those. I sense you might have a question. Did you have a...
Yes.
Okay.
With this in place, would it not encourage fraud?
Would it not encourage?
Would it not encourage fraud? with the indemnity program? You see what I'm saying?
I guess, so the way I've often heard that raised in the past would be, if we have an indemnity program, does this effectively enable bad behavior? Not necessarily just fraud. When I think of fraud, I just think they could commit fraud anyway, you know, in that sense, you know, with or without it. If somebody's going to cross that line, then they've made some life choices that enables them to feel like they can do that one way or the other. But that's probably the most important sort of, in all the conversations and interactions I've had over the years, that's come up the most commonly. If for someone who says, if they're looking at it from both angles, they'll say, well, one thing that concerns me is I'm afraid that we're setting up a program that enables somebody to engage in bad behavior and takes advantage of it. So that comes up, or that sentiment comes up. I don't know that it's actually occurred where it encouraged that bad behavior. Let's see, I mentioned 2 or 3 states to you. Kentucky. So what Kentucky does, they treat this on a calendar year by calendar year basis, meaning by January 31st of each calendar year, if a producer wants to opt out of the program, in other words, they don't want to pay the assessment, they don't want to, or more specifically, they don't want to contribute to the indemnity fund, there's a form, it's on the Kentucky Department of Agriculture's website. They submit that at the beginning of that year before January 31st. And that, once that's submitted, they are then entitled to a refund. So they will still pay the assessment at the point of sale, but they can get the refund later. What they won't get for that calendar year is the benefit of the indemnity fund. So they're out that year. And so if they deliver grain to a warehouse and your real risk is going to be with dealers mostly, your real high dollar risk is going to come through that dealer. And that's simply because they're just buying large quantities of grain. And, you know, the old Popeye, I'll gladly pay you Tuesday for a hamburger today. That's kind of what's going on. So, you know, your money, your value's in somebody else's pocket, and you're waiting for the money. So your dealer, that's really where most of your risk is. And so they're out for that year. The way their statute's written, it does not impact a previous year where somebody paid in or a subsequent year. They just go calendar year by calendar year. So you could, you know, if you were a gambler, a producer could say, I'm just going to pay in on even number years, and I want to opt out in odd number years and see how it goes. You know, but it just resets every year. The state of Tennessee, they don't have a refund. What they do is they have a similar form, a similar process. It has to be notarized. The producer would submit that to the Department of Agriculture, and then they receive a certificate from the state. And they take that certificate when they deliver grain, then they can present that, and they're not to be charged the assessment. But they're also outside of the indemnity fund. Tennessee does allow a process by which somebody can get back in the program if they want to. I mentioned Louisiana. They're similar to Kentucky. I apologize. They're similar to Kentucky. They have a different date. They use April the 1st. Next slide, please. Some important exceptions. This could very well come up in your process and your deliberations. Who all will pay or who all should collect? Sometimes you have producer-to-producer transactions, and states will exempt those. Sometimes you have transactions, and a classic example would be a poultry integrator. Poultry company. They'll often be, like Arkansas is, Tyson Foods headquarters, and they purchase more grain than anybody. They are exempted from collecting this assessment on those transactions. So those are outside, can be, and often are outside. That's just up to how the state law sets it out. If you were to look at the Arkansas statute, you would see the term end user, and they have a statutory definition for that. It doesn't use the word poultry integrator, but that's what they're talking about. And then dealer-to-dealer transactions. Sometimes those are exempted. So in other words, the assessment's just paid the first time. It's not repeated as that grain is resold. Next slide, and I think we're pretty well towards the end. This is just some miscellaneous things I wanted to pull together. As I mentioned earlier, many of these states do have investment provisions, so they expressly authorize the board with, oversight and so forth, and guardrails associated with it. But they can invest money in certain ways in order to help improve the financial status of the indemnity fund. Some of them don't have that. I just want to make clear about that. That isn't some of those. I mentioned the producer refunds. I think Indiana would be an example, but you sometimes see states that have confidentiality provisions. In other words, those farmer members or whoever comprises that board that oversees the indemnity fund, they're sworn to confidentiality. They're subject to penalty if they were to go talk about it, for example, without proper conditions or approval to do so. Administrative costs are an important part of this. That would have to be given some thought. Those often have some guardrails with it where the statute will limit, it'll say no more than $200,000 or no more than a certain percentage in a fiscal year can be expended on administrative costs. But aside from just the costs themselves, the administration is an important part of this. Schedule of payments. There will be states that how often does this assessment need to be delivered? It ranges. Some of it is month to month, similar to the way the checkoff might work. Others are quarterly, and some will mix it. In other words, the warehouse or the dealer reports monthly to the department, this is what we took in. They do that, say, for 3 months, but at the end of that quarter, they pay. That's when that transaction actually occurs. An advantage to that approach is that it is albeit modest, but it's a way of putting some guardrails inside the system such that for someone to commit fraud doing that, they got to do it 3 times. They have to actually play with the numbers each month because at the end of it, that check that comes, it ought to add up to the 3 that got submitted. It just provides another layer of paperwork that you can trace through on. Administrative costs, typically those are just passed right through, but there are states that allow the dealer or the warehouse to obtain or retain and offset the cost of that paperwork on their end. In some states, I would say, let me back it up and say it this way. Most states actually try to get the loss covered at 100%, but not all. Some will limit it at 75%. There's another state that limits it at 90%. And there's even a state or two that in their statute, they intend for the losses to be covered not only at 100%, but if it's not all paid back in that first year, that when that cap is reduced and that trigger comes back, that the money that comes in is to go out to those producers until those claims are at 100%. So you can mix and match that, all kinds of ways. I think that's probably my last slide, but next slide. So I'm happy to answer any questions. I tried to make that as tight, as succinct as possible. And help anywhere I can here. So,
what percentage is federal license and state license in Arkansas?
I don't know. I don't know that. I don't know that. I'll find that out though.
Okay.
I looked once, and I didn't find it on the Ag Department website to kind of do a comparison. And then you would break it down still if you want to go by quantity. They're not all obviously the same size.
Right.
So you could do number of operations and get that. That wouldn't give you necessarily their storage or their purchasing capacity.
Thank you. Mr. Vice Chairman.
Thank you for coming, Mr. Pittman. You've been an immense resource for this committee. In your experience with a voluntary program, what is generally the participation rate in a voluntary program in other states?
I think they're generally pretty high. That's word of mouth. I don't have a way to just independently go verify that. I would say 80% or higher. And I would say it's the same, pretty much the same on the checkoff programs when there's a refund available. That's usually a very high level of participation, meaning a very high level of people not requesting refunds for it.
So you're saying that with a voluntary program, you're expecting somewhere over 50% at least that would participate in the program?
I think that would be reasonable to expect.
Okay. Additionally, you and I have spoken in the past. Would an ability for the state then a subrogation type agreement come into play here? From what you've shown me in some of these places, that the program could go after the grain dealer. In the situation of a bankruptcy, which of course we would have to have some counsel from some learned bankruptcy scholars, and I am not one of those, but we would like, of course, to keep the ability for the state to seek subrogation for anything paid. Is that still doable from your perspective?
Okay, so I think what you're probably envisioning is a scenario where you got two realities playing out. You got the indemnity fund claim by a producer or producers, and you have a bankruptcy process that's playing out. And a situation where a producer could end up being compensated for more than 100% of the loss. Like they got 100% of the loss out of the fund, and then they got something out of bankruptcy. Is that? Okay.
That'd be one of the situations, yes, sir.
I think you could do that. You know, these states do often have provisions that say that, you know, that dealer or that warehouse is subject to having a process put on them that they're going to make up for that loss. And so unless there's something that I wouldn't know about quirky, like in the Mississippi Constitution or something like that, or in some weird case law, you know, something that's kind of out of left field, then I think that's doable.
Just one more for this round. Generally, what would be an effective average cap or size of these funds? Can you give us some idea?
Yeah. So I showed numbers, but I think you have to think context. You got to go behind that. So some of the states that have these, you know, they're going to be, you know, they may not be, like Kentucky is not a state that I would consider to be a huge grain state. So their indemnity fund is, I mean, it's not unimportant, but, you know, their fund at $3 million to $5 million, whatever that was, that could be a lot lower than what, say, another, like take any I state, take Iowa, take Indiana, take Illinois. A loss there, if it gets big, it's going to be a big one. Mississippi's a big grain state, particularly, you know, and keep in mind, and this would be something that would be specific to really just half a dozen states, 5 of which are in the South, but rice, you know, is a commodity that's not produced in, you know, nationwide. And so Mississippi is one of those top 6 states of, so you had to consider that too, in terms, if you wanted to include rice, and how you set that indemnity as well, and that level. The losses, I took a long-winded way to say the losses could be higher in Mississippi, simply because of the value of the crop, particularly soybeans.
So would this 20 million range, I mean, you're never going to make everyone whole from this fund, and I don't believe that's the intent, but I think the intent is to keep our farmers who are already struggling, who are subject to bad actors at some point, as we all are, to allow them to actually keep their farm at some point.
So there's always a chance that it wouldn't make them whole, 100%, if that's how we're defining, you know, completely whole. But there is a possibility it could, particularly if you catch it early enough before it gets above that 20 million. If it sits at 5 to 10, 12 million, you're at 20 million, people will probably get back, you know, paid whole out of that. That's possible. Was there another part to your question? It seems like there was.
I guess really the question was in the 20 million range, 20 to 30 million, 15, you know, anywhere in that range, is there a number that you believe may be a reasonable number for our state?
Yeah, I think I'd probably, at the low end, feel like 12 to 15, and then at the higher end, like 17 to 20. That's in my sort of pocketbook guess at it.
Thank you, sir.
Any other questions from any of the members of the committee? Yes, sir. Senator Hickman, go right ahead.
Just a couple of questions about the general setup. I think we were talking about refunds and opt-out and opt-ins. So if we set it up where there is no refund or opt-out, how does that work? How does one get in later, or does everyone who's going to get in have to get in on the front end?
Okay. So if it's, go in like chronological order. So if it's mandatory, then everybody pays in until it hits the cap. And you hit that. So I think probably what tell me if I'm reading.
I think we're generally talking about voluntary. So if it's voluntary.
Oh, okay. All right, then I misunderstood. Then ask me again, please. I
So
misunderstood.
if it's voluntary, let's say I'm a producer and I decide not to get in on the first year. Do I just get in the second year? Or
Okay.
How does that work?
All right, so it depends on how you set it up. So the example I gave earlier was Kentucky. And now, so let me put it on a spectrum. In some of these states, you request a refund, you kiss it goodbye. You're not getting back in. And that's a most strict, kind of rigid way to look at it. And that's about as close as you can come to, you're basically still mandatory in a way, but you're saying you're offering a refund. So a person doesn't want to pay in, and they all take that refund, they're out. Now, some of these will come in and have a way to get back in, pay arrears, add a penalty with it. The example I gave earlier, to me, I think is the cleanest administratively. If you get into the voluntary, across the Rubicon, say you have a law in place here in Mississippi, and you're going to make it voluntary. I think the model Kentucky uses, in full disclosure here, as a Rotarian, I'm always thinking of the four-way test. Is it fair to all concerned? And so that's a bias I have there. I just want to make sure I put that out there. They do it year to year. And so let's just pick a 5-year period. I'm the producer. I pay in year 1, year 2, year 3, year 4. In year 5, I opt out. If I deliver grain during that calendar year and that grain is attached to an insolvency, so that delivery occurred in that calendar year, I'm toast. I'm not going to participate. Now, if I had delivered grain in year 4 and for some reason I hadn't been paid yet, the way Kentucky does it, a previous year or subsequent year does not impact that calendar year that you've opted out. Does that make sense?
Yes. So another question. Let's say we set it up like Kentucky. What does Kentucky do if one opts out until the fund has reached its cap? And there's no payments? Like if you reach the cap,
okay,
there's no payments.
until you reach the cap. That's a great question. I don't have a good answer for that, by the way. I think that there's 2 places where this, in my mind, you have one, it's not the same exact thing, but it's similar, where you reach the cap, and let's say everybody's lucky and it sits dormant for years. There's no insolvency, there's no claims made against it. Well, in that time, there's some new farmers that come into the system. They never pay in, and then there's a loss. I think in that instance, they're basically, they have a windfall. They didn't have to pay in. Now, if it gets depleted, they'll kick back in. If it hits that trigger, that lower minimum, they pay back. The other that you're relating, I think that's a tricky thing. I don't know exactly how to tackle that. I have, and I don't recall. We've mentioned the task force. I think I should know everybody on the task force. I think I've visited with everybody at one point or another, although I never really get to put a face with it until I drive over. But there's somewhere in that mix, there was an issue of setting up as a revolving fund so that there's a point where, and some of these folks can describe it better than I can, where it could circle back to those who paid in early. Once you hit that cap, that they actually receive some type of basically a repayment. The money's returned to them so long as it stays at that cap or above.
One final question. I think we were just talking about, like, if the funds are set up to let's say our cap is, I think you mentioned like 16 million or something like that, maybe a good cap. Let's say our cap is that, but we have a situation where you have, say, 20 or 30 million affected in an incident. Is it administratively determined how and who gets what and how much a person is taken care of in that process?
Yeah, so then if you get in what you're talking, so basically you have X amount in the fund, but the number of claims exceed that. And that goes into that portion where I was talking about you have to have that claims process set up. So typically what you would do, you would have like, you have to have a way of determining like whatever day one is. If that's an administrative determination by the commissioner, if it's a filing of a bankruptcy, whatever that, or the first slow pay, whatever that gets attached to, then claims are, you might put a 90-day window with it. And they have to be filed within that time. But just because a claim is filed doesn't mean it's automatically going to be approved. That board has to review that. and they have to either approve or deny. So if you have it tied to a window in time, you know it closes at a certain point in time, then you would know, okay, we've got enough to do 100%, or we're going to have to do it at 80% in order to be able to do this. So that's how that would work. That's exactly the kind of stuff you have to think through setting this stuff up. That's a good question.
Thank you.
Anybody else have a question for Mr. Pittman? Mr. Pittman, thank you so much for coming today. We owe you supper.
Hey, we're all good, but I'm glad to be here. I'm glad to be a resource even after this as you work through it. Believe it or not, you call us at the Ag Law Center and we actually answer the telephone. And I'm more than happy to be a resource. For me, the ability of being objective and nonpartisan, the world is my friend. I get to go and I can talk to everybody.
And I hope I didn't mess up your deer hunting when I called you that day.
No, I was in between, waiting for the dogs to circle back. We were good.
Thank you so much.
Yes, sir. Thank you.
Appreciate you. I think up next we have is Farm Bureau with Mr. Ted Kendall, Sonny Jameson's brother, adopted brother, I believe. I remember Ted from the wild days at Mississippi State with Sonny Jameson.
Thank you, Mr. Chairman, and you know, I know some things on you, but you know some things on me as well, so I appreciate it.
Goes both ways, doesn't it?
It does. I appreciate the opportunity. And also was thinking, you must have made a better crop than I did, because I couldn't wait till January to get my money.
Well, that's because I had some cows I sold.
Okay.
Thank you for coming.
Like Mr. Chairman said, I'm Ted Kendall, a row crop and beef cattle producer from Western Hinds County. Also serve as the Central Area Vice President for Mississippi Farm Bureau, and I'm here today to represent Farm Bureau. We've had a lot of discussion about the issues this fall, and just wanted to say that from the Farm Bureau perspective, obviously, as soon as the problem surfaced, we, began to have discussions. We've had county meetings, regional meetings, commodity meetings, and at most of those meetings, the issue and the incident at the elevator in Greenwood was topic number one. It's devastating for folks involved, and look, there are people involved on the eastern side of the state too. So, I mean, it's a Delta issue, but it's also an issue in a lot of other places. And it's devastating. It's tragic for a lot of those farmers and their families and others in the community. So we've had discussions. As you probably know, we have a resolutions process that goes on throughout the fall, throughout the year really, but it ramps up in the fall. We had policy on slow pay in our book for years, but we've revisited that, and oh, my glasses. Part of what I'm here to do today is to relay to you the revised and new policy that we added this year as it results to prompt pay and the issues we've been facing. So, number one, and it deals with the indemnity fund. We've had policy that supported an indemnity fund, but we've just revisited and updated it. So Farm Bureau supports a voluntary farmers indemnity fund similar to surrounding states, and the key word there is voluntary. So that would protect Mississippi grain farmers from failure to pay by licensed grain storage facilities located in Mississippi. Producers would pay an assessment not to exceed 0.2%, it's 0.2% of market price per bushel to fund the grain indemnity program. So we would support, most of the things we've talked about here today as it pertains to the indemnity fund. Secondly, and this is new policy, we support the creation of a slow pay hotline at Mississippi Department of Agriculture and Commerce to expedite reporting of slow or non-payment on commodity contracts. And then thirdly, we support the increased funding for Mississippi Department of Agriculture and Commerce to fully staff the grain dealers and warehouse division for the purposes of investigating slow pay events. Those are the policies that we adopted this fall, and I think, you know, obviously they're all pertinent to the issues that we're facing, and I'd be happy to answer any questions. Try to.
Any questions, members? Ted, the slow pay, I've heard about this for 3 years with Express Grain. And my good friend, he's a good friend of mine, the guy that runs the elevator where I live, he told me 5, 6 years ago that there was going to be a lot of hurt coming from the Express Grain because their basis was so good that it was too good to be true. But anyway, if Farm Bureau wants to do the indemnity program, volunteer, you know, we'll sure try to get it passed.
Okay. All right.
Mr. Chairman, excuse me, I've been calling you Vice Chairman. This is Mr. Chairman of Forestry. I
Well,
forgot.
that's what I heard. Congratulations.
Yeah. That and 25 cents won't buy you a Coke anymore. You know, I understand the need to do the reporting, the 1-800 number, or whatever it may be. You know, we're at a time where we're evolving substantially in our technology. Would there be any opposition to expand that into a electronic reporting system as well?
I can't imagine that it would.
I just feel like we would be going the wrong way with creating a 1-800 number when we're so evolving all of our reporting statistics, our e-grain statistics that are immediate and things of that nature. I know you can only do what's on that resolution as far as what Farm Bureau would support, but I couldn't imagine you would oppose that.
Well, and this, you know, points out a hotline. I'm not sure that's not necessarily a telephone line, I wouldn't think. So, yeah, I can't imagine that any means wouldn't be welcome.
Just not certified mail anymore.
Exactly.
Okay, I understand
I think,
that.
you know, to me, just creating a process is what we need to do so that there's a way to get it done.
Yes, sir. Thank you for being here.
All right.
Anybody else?
Any other questions?
Ted, thank you so much
All
for
right.
coming today. And I know you've been working hard on this and appreciate your time, taking away from your family and your farming and being a granddad also with those good-looking twins you
Sure,
got.
thank you. Well, this is important, and like I said, it has affected a lot of people, and even beyond that, you know, small-town folks, and it's important for us to do what we can, I think.
And you're right, I've got constituents that have money that's owed to them from
Yeah.
this, and they're going to, anyway, it's bad, bad deal. Thank you for coming today. Next up is Mr. Frank Howell with Delta Council. Okay, I'm sorry, excuse me. I don't see you on the list here, excuse me. Welcome.
Thank you. Thank you. And Frank makes me do all the heavy lifting. So, no, Chairman Younger, I do appreciate the opportunity to be here and thank the members of the committee for a chance to participate in this hearing. My name is Patrick Johnson, and I'm a cotton, corn, soybean, and rice farmer in Tunica, Mississippi, and also serve as the current president of Delta Council. Delta Council is a agricultural and economic development group located in Northwest Mississippi, and our membership is comprised of farmers, elevators, bankers, and many other associated agricultural businesses in the Delta. First, we'd like to thank the state of Mississippi for the way they've responded to the recent bankruptcy that has roiled the economy in the Delta. As you can imagine, a 9-figure bankruptcy has enormous implications for the economy and the livelihoods of hundreds, if not thousands, of people in the Mississippi Delta. It goes without saying that this tragedy should never be repeated if possible, And we hope that some of the things we've discussed and are discussing today could lead to meaningful efforts so this does not reoccur. We also need to be mindful of the fact that any regulations or legislation that we implement in the wake of this disaster should not have unintended consequences for the other warehouses and grain dealers who have been operating successfully for many years and continue to do so with utmost integrity. The principles I'm going to talk about this afternoon have been discussed among many members of Delta Council who are involved in all aspects of grain handling. The movement of grain between farmers and elevators and other buying points is a complex effort that is governed under numerous federal and state laws. These laws are designed to level the playing field and ensure the movement of goods from the farmer all the way to the end user. Whether that be an animal feed mill plant in South Mississippi or directly to a foreign country across the ocean. We have large billion-dollar elevators on the Mississippi River. We have smaller country elevators located in the interior that play a pivotal role in the movement of grain, and we have other entities that purchase that grain directly from the producer for other ancillary activities. All of these functions are very important to the profitability of agriculture in the Mississippi Delta and in the state. And it is important that we design a program that minimizes any disruption or financial hardship to good actors who are already engaged in these businesses. As has been discussed by others, Delta Council supports the concept of a voluntary grain indemnity fund, funded at a maximum of 0.2% of the value of the bushel of grain. Delta Council supports the concept of an indemnity fund voluntarily paid for by farmers to cover losses of participating farmers in a future event like the one we've seen this year. Delta Council supports the continuation of the state-licensed elevators and warehouses. Discussions with people intimately aware of the mechanics of federally licensed warehouses under the U.S. Warehouse Act have attested that its oversight does not appear to be significantly more robust than the state license, especially if we could provide more teeth to the latter. The fact that there's no home for grain dealers under the federal license makes it even more imperative that we maintain the dual system. If we mandated that all elevators have a federal license, then the result would make many small elevators have to continue to meet the state dealer bonding requirements while maintaining a federal license at the same time with a significant cost burden. In a similar vein, the idea of increased bonding has come up, and we feel like that's not a very good solution either because of the cost of higher bonding to the elevators that we know ultimately would be passed on to farmers. In order to strengthen the state licensed elevators and dealers, we request that the legislature look at enhancing the auditing components of this function. A routine and unannounced audit that includes the measurement of all grain in a facility compared to its storage obligations is a measure that would go a long way in determining if there are problems with a specific facility. Also, slow pay or whistleblower hotline that alerts the Commissioner of Agriculture to potential problems and then allows for enhanced oversight and auditing measures to determine if there is an issue seems to be a good idea that has been implemented successfully in other states. Finally, and most importantly, we hope that any efforts to codify and implement the measures we've mentioned and any others would involve the elevators, dealers, and farmers from around the state to ensure there's minimum disruption and added cost to their operations. We don't and probably never will know whether these measures or any others would have allowed the state or others to detect a problem in the LaFleur County example, but these seem to be meaningful and positive actions that could ward off similar problems in the future. And again, Delta Council thanks you for working to ensure the integrity of our agricultural businesses in the Delta and the state, and we appreciate the opportunity to be here at this hearing.
Thank you, Patrick. How, do you know the difference, like if you had a small elevator that handled, say, 2 million bushels or a million, what would be the difference in the cost on getting a USDA license compared to a state license?
Now, I would have to refer to that chart that has some of those details on it. I don't know the specifics. I know that in our conversations with some of the smaller elevators that have state licenses, and I mean, some of these have been operating 30 or 40 years, and they like their state license. But I'm not sure about the specific cost differences.
The elevator that I go to holds 3 million bushels, a little bit more than that. $3,195 a year is what their license costs with the USDA.
Yeah.
Now, I don't know what that would cost with the state. Any idea, Mr. Commissioner, or?
The cost of getting a license is not the issue. The cost is, I've had 4 elevators, small elevators in Mississippi tell me if they were to be required to maintain that $200,000 net worth requirement, it would put them out of business. So the cost of the unintended consequences is greater than the cost of a license. That's just one example. You have to take into account there are some very, very large regional, national grain warehouses and dealers that are doing business in Mississippi. To them, it's easy for them to get one license, USDA, pay whatever the cost is, even if it requires more net worth, more, cost of audits, all that. But then take into account a small elevator that's been around a long time in Mississippi that is not that large and doesn't have that type of net worth and can't afford those levels. And you don't want to have, I don't think this committee ever wants to have the unintended consequence of putting somebody out of business.
Right. Thank you, Mr. Commissioner. Patrick, thank you. Is any questions from the committee? Patrick, thank you so much.
Thank you.
And thank you too, Frank. Do you want to testify, Mr. Frank? Hey, thank y'all for coming, and it looks like that's it. I've got Billy Tabb, a good friend of mine on here. He's a farmer. He suffered getting slow pay last year from Express Grain, but he had family come in, and he didn't feel like coming, and I told him, don't worry about it. I would speak for him. But I want to thank everybody for showing up today, especially my committee members, and I just hope that we can fix this where it doesn't happen again. Everybody have a Merry Christmas, and thank you so much for coming.